Good morning, everybody, and welcome to our Premises Personal Licences Subcommittee on Wednesday, the 13th of May 2026 it's just after 10 now, 10:05. I'll now adjourn the meeting, hopefully for not too long while we sort out some technical difficulties. Thank you. Good morning and welcome back to our Premises Personal Licences Subcommittee. After our short adjournment, we still have a few issues. We'll move to item 1 on the agenda, election of a chairman for the meeting. Do we have a proposer? For who? For me? Yeah. Councillor Cousins and Councillor Casey. And just to introduce, we also have Councillor Bill Davidson, who's our standby member today. Thank you. So move to item 2, which is apologies for absence and substitutions.
Thank you, Chairman. We've had no apologies for absence or substitutions.
Item 3, minutes of the last meeting can be found on pages 5 to 8. Can we confirm that these are correct? Councillor Cousins, seconded by Councillor Casey. Thank you. Item 4, declarations of interest. Councillors are invited to declare any disclosable pecuniary interest, other registrable interest or non-registrable interest and the nature of it in relation to any item of the agenda. There are none. So we'll move to item 5, which is our first item today, which is the report of the Assistant Director of Corporate Policy and Support, A1, variation of a premises licence, Highfield Grange Holiday Park, London Road, Clacton-on-Sea, CO169QY, can be found on pages 9 to 62. Before we move to this item to be presented, I would just like confirmation from the applicant's representative or from Mr. Andrew Kemp if he could make a signal on the live stream, because he's unable to come through by voice, that he's happy for us to proceed with this today. If you could.
Happy to proceed, Chair.
Yeah, so he's agreeing with that. You can all see that he's agreed. Lovely. So we'll move to this item to be presented. Thank you.
Thank you, Chair, members. We're here today to hear an application submitted for variation of a premises licence under the Licensing Act 2003. The application is in relation to Highfields Grange Holiday Park located in London Road, Clacton-on-Sea. Application number 2600177 Prem 3A. The premises is described as a caravan holiday park with function rooms, bars offering food, drink and entertainment. Within the application, all indoor licensing activities are to remain unchanged. The variation is seeking to amend the outdoor activities and timings and update some of the licensing conditions. Outdoor licensing activities to be amended as part of the variation is the performance of dance, exhibition of films, performance of live music, performance of recorded music, performance of dance and other entertainment falling within the Act. These are to be amended 11 till 2300 hours Monday to Sunday. Amendments and the current conditions can be found on page 17 of the report. A plan of the premises and location plan can be found on pages 41 to 43. We've got Jonathan Smith from Popperson Allen Solicitors presenting the application today, should members have any questions. Representations can be made either against or in support of the application. All responsible authorities have been notified of the application and consulted as part of standard procedure, and no representations have been received from those. As part of the consultation, we've received 7 representations from members of the public, and these can be found on pages 53 to 61. Each application must be considered in its own rights and own merits, only on what might impact the 4 licensing objectives, which are the prevention of crime and disorder, the prevention of public nuisance, public safety and the protection from children from harm. We have 2 representations here today, which I believe would like to speak and that is Objector 1 and Objector 4 in the report. All of the relevant human rights information and Section 182 guidance are detailed within the report. Chair and members, you're therefore asked to determine the application, taking into account the application in its own rights and merits, as well as all the information submitted as part of the report and the hearing today. Thank you.
Thank you. Do we have from our committee members, have we got any questions of our licensing officer? Councillor?
Any objections to the police? Anything else? Mike?
There's been no objections from the responsible authorities.
Okay, thank you.
No further questions for our licensing officer? No. So we'll move to the applicant's case. So the applicant or their representative can present their case to us. Thank you.
Thank you. Councillors, yes, my name is Jonathan Smith. I'm a solicitor from Poppleston Allen. I'll present the case today. You have Andrew Kemp, who's on the live feed, unable to speak to you, but observing. He's the licensing manager from Parkdean Resorts. And sat next to me to my right is Tom Joyce. He is the general manager of Highfield Grange Holiday Park. So the application, councillors, as you've heard from Mr. Cook, there's three aspects to it, two of which I can deal with fairly easily, and then I will concentrate on the third in greater detail. So we're looking to extend the hours for regulated entertainment. I have to stress, councillors, that is just outdoors. There's no amendments made to the hours for indoors, which remain as they are existing. To remove one condition, and I'll explain the reasoning behind that shortly, and then to amend another condition on the licence. A little bit of background for you. Park Resorts Limited, who hold the premises licence here, they're part of Parkdean Resorts Limited. They operate some 66 holiday parks around the United Kingdom. They actually have a total of 4 within your licensing authority. They also have Naze Marine, Valley Farm and Wheelie Bridge. So they're well known to your responsible authorities and to you councillors as local operators. There's been some £5 million development at this park over the last 12 months or so, which has enhanced the outdoor area with a canopy covering to an area. There is a small performance area, which I'll show you some pictures of shortly, councillors. There's been a new outdoor adventure play area, a bounce park, high ropes, as well as a complete refurbishment of a number of the venues on site, including the show bar, hat tricks, and the boat house. So that's part of a £5 million development. And it's something that Parkdean Resorts are doing more and more, and indeed have done since COVID, because since COVID hit, there has been if you like, a desire or want to make sure that there are facilities outdoors for people, not least because some people feel more comfortable outdoors, but should, dare I say it, we ever have anything similar again, we need the facilities to be outdoors as well as indoors. So there has been a move through various what they call springboard parks for enhancing outdoor areas. The actual changes and the plans, though, that you have attached to these licenses, these plans were approved some time ago, so we're not seeking any approval to the alterations. It's purely the hours for the outdoor entertainment. We, prior to submitting the application, there was a meeting at residents on Jubilee Avenue, which, if you know, I assume you know the park. Jubilee Avenue runs to the rear of the park behind the complex buildings. There are 70 houses, I believe, on that road, from 70 houses. Those residents were all invited to a meeting on the 16th of March. We had some 8 or 9 households attend that meeting. with the park, so we could explain what the application was we were submitting. We also invited two of the local councillors, Councillor Chris Amos and Councillor Mike Skills Jr., to that meeting as well, but they didn't attend. They were not there. Mr. Joyce sat next to me, provided his email address so that if anybody couldn't attend the meeting, they were able to email him separately, and I think Rebecca did do that. So they were able to contact Mr. Joyce separately outside of not being able to attend that meeting, and I know Rebecca couldn't attend that meeting. There has been some reference to the fact that some residents didn't know about this application in the representations. Well, there were a total of 19 notices displayed about this application, 10 on London Road and 9 running up and down Jubilee Avenue, which we didn't actually need to put the 9 on Jubilee Avenue because the road doesn't actually, we just need to put it on the boundary abutting a public highway. So we put notices up in 19 different locations. I know there's no issue raised by the licensing authority on this point. The pictures, councillors, hopefully you got my bundle of extra information for you, which you've been able to have a look at. Did you, councillors? Yep. So one of the documents in there was I provided some pictures of the outdoor area, the external seating area, and one of those pictures on page 2 of 4, actually both the top picture on page 1 of 4 and 2 of 4 shows the stage area. It's perhaps quite grand to describe it as a stage. I think Tom next to me would describe it more as a performance area. It's about 2 metres by 2 metres. It has a small roof on it, and that is where a performer would be positioned. On the wall you can see in that stage area there's a white box, and within that is the audio and the AV equipment. That is the sound limiter that you must plug your equipment into in order to play any music whilst you're outside on that in that performance area. So there's some pictures there of what it looks like. You can see the various canopies, the umbrellas that are up. It just gives you an idea. It was a very nice day when those pictures were taken. It just gives you an idea of what it looks like if you have not visited the park recently. So the 3 aspects of the application, I'll deal with the 2 aspects which will probably entertain your minds less than the third being the change in hours outdoors. So the first change, councillors, if I could ask you to turn to your agenda report and look at page 51. So on page 51, that is our current premises licence, councillors, and it's annexed to condition 1 I'm asking you to have a look at right at the top. It's a rather old-fashioned condition which talks about members of the holiday park. Well, the application is to remove that completely. The reason being is that we may in the future look to provide day passes or sell day passes to people who aren't necessarily staying on the park. But also actually some of the residents living on Jubilee Avenue at the meeting did actually say, well, we'd quite like to come to the park. You'd have to be a member of the park, which you're made a temporary member when you're a holiday maker. So we wouldn't be able to allow, if you like, local residents onto the park either. So the first part is to remove condition 1 completely. And then condition 3 within Annex 2 refers to a maximum noise level at which music must be played outdoors. It doesn't actually say where that's measured at, the 65 dBA. We're requesting that's replaced, and if I could ask you, councillors, to turn to page 36 of your agenda. And you'll see on page 36, I'll just wait for Councillor Casey to hit the page. Page 36. So on page 36, under prevention of public nuisance, we've asked that the condition be replaced when live and recorded music is taking place outdoors. The maximum noise levels are those that are stipulated in the noise assessment report, which has been approved as part of the planning application. If we were to have the 65 dBA as listed, that would be inconsistent with the noise impact assessment report, which I'll go through. So we would actually have a different requirement under the planning than under the licensing councillors. So it's to replace that condition with reference to the noise impact assessment report. There's been no representation made about change to those conditions by the responsible authorities or by local residents. So I'm going to move on to the hours which we're requesting are changed outdoors, and Mr. Cook has outlined those for you. We currently have permission for performance of dance, live music, recorded music, entertainment of a like kind, and the performance of plays on the licence from 11:30 in the morning till 7 p.m. And we have permission for films on the licence, councils outdoors, from 1400, 2 p.m. to 11 p.m. And we're seeking to amend all of those times to read from 11 a.m. to 11 p.m. So for performance of dance, live music, recorded music, entertainment of like kind and plays, that is providing for an extra 30 minutes in the morning, starting at 11, not 11:30, and an extra 4 hours in the evening from 7 p.m. to 11 p.m. And for films, it's asking for an additional 3 hours in the morning. We can currently start films at 2 p.m. We're asking for it to start at 11 a.m. Now, that's the fairly easy bit, councillors. We then get into something, and I have warned your solicitor I would be mentioning this, something to do with the live, well, it's called the Live Music Act, councillors, and the general deregulation of entertainment, which you're probably familiar with if those of you who can remember Fergal Sharkey from the Undertones. He was a great proponent of pubs playing music in their beer gardens, outdoors, indoors. You shouldn't need a licence for it. So back in 2012, the House of Commons, House of Lords passed the Live Music Act, and there's been various deregulation of entertainment since then. And that provides, and this is where I know that many local residents struggle to understand fully the concept of this, but this provides for all of those forms of entertainment I've just mentioned to you, other than films, to actually be held from 8 o'clock in the morning to 11 o'clock at night for up to 500 people. The one proviso with live and recorded music is, though, that in the area you would need to be able to, within the licensed area, it must be being used for the sale of alcohol for consumption on the premises. So what we're requesting is actually less than we could do anyway under the Live Music Act for plays, live music, recorded music, entertainment of a like kind and plays. So you may say, well, why are you doing it then, Mr. Smith, if you can do it anyway? We're doing it because it's not the easiest bit of legislation to understand, not even for managers like Tom. So it's easier if it's on the licence. Everybody knows where we stand in terms of our client. Residents know where we stand. The playing of live and recorded music under the Licensing Act between those hours would actually necessitate a bar being open and selling alcohol. So let's say they did decide to shut a bar at all the bars at 9 o'clock at night, then you would have to stop the music at that time. So it does require the sale of alcohol. The law could change, but it also allows us to provide some assurance to you and to local residents that we're doing this. It's on the licence as opposed to relying upon the Live Music Act, and we're putting forward mitigation measures which we'd ask you councillors to put on the licence as a safeguard. The first obviously being to refer to the noise impact assessment, and that's the levels that music's played, but I'm also going to invite you to attach as a condition that we implement and maintain the noise management plan that you've got in your pack, and which I'll come on to. So that's why we're doing it, councillors. Obviously, the conditions that we're seeking to change fall outside those permissions under the deregulation of entertainment. I hope your solicitor had summarised the deregulation as easy as I can do. It is all summarised within Chapter 16 of the National Guidance. to the Licensing Act and also within Section 177 and Schedule 1 of the Licensing Act. So I'll leave that to your solicitor councillors to brief you. I provided you with a copy of the planning permission, which was approved last year for the works outdoors, and there is a condition on the planning permission that it's condition 12, that prior to the use of the stage, the limiter must be set in accordance with the noise impact assessment dated the 19th of January 2024. And we've installed the AV equipment. It's on the wall in the white box you can see on the photographs, and that's got the limiter inside. We then made an amendment to that planning, or excuse me, requested an amendment to that planning because the stage at one point, excuse me, was facing side on. It was facing, I'm trying to think directionally which way, it was facing towards the entrance to the park. And we changed it now so that it's facing directly away from Jubilee Avenue. So it's like it's been rotated sort of 45 degrees to the back. It now lies against the back of the complex building, facing into the park and away from Jubilee Avenue. So we repositioned the stage, and an amendment was approved to that change in position of the stage and other equipment outdoors on the 18th of September in the planning that you have. And the Environmental Protection Officer said, I have no objections to this as long as the noise impact assessment is still observed and is still implemented and you still set the limiter at those levels. But the benefit with the stage being reorientated is it now points into the park. The speakers point into the park. And please bear in mind, councillors, there is actually a complex building between our stage and also Jubilee Avenue. So, as part of the planning, the noise impact assessment was completed and submitting to your planning offices. And as I said, your environmental protection team, the experts in noise, were happy that impact assessment would mitigate any issues, but it had to be conditionalised as part of the planning. I don't know if you want me to take you through that, councillors. It's quite technical. Would you like me to run you through it or just give you a brief summary of the conclusions? A brief summary, okay. All right. So what they do is they undertake background noise readings to establish, if you like, the base background noise levels. And then the guidance is that any music noise should not exceed, should not be played at more than 5, at a level that exceeds that background noise level by more than 5 decibels at what they call the NSRs, the nearest sensitive receptors, noise sensitive receptors. So they measure the background levels, they ascertain what they were, being 42 and 39, 42 in the daytime, but they do it also in the evening, so that's from 7 p.m, so they don't just take one measurement throughout the whole day, so it's 42 during the day and 39 in the evening. That means that at any noise receptor it can't be more than 47 dB during the day and 44 in the evening, because naturally the background noise levels fall off after 7 o'clock, as you would expect. So the acoustic experts then, they model the sound. They say, well, if you have your normal form of entertainment that you do here with your normal musicians that you partly intend to use, then we say you can't play the music any louder than this before 7 o'clock and then this level after 7 o'clock. And provided you do that, the noise levels at these nearest noise sensitive receptors will not exceed those levels of 47 and 44. And those levels then are on page 16 of the report, which when measured 10 metres from the front of the stage is 76 decibels between 9 and 7 and 73 in the evening after 7 p.m. That's measured in front. Now that is low. I did one the other week for the same company, and it was, that was in Norfolk, it was considerably higher than that. But that does reflect the fact that Jubilee Avenue is, it is to the rear of the complex buildings here. I would ask you also to bear in mind, councillors, we have somewhere in the region of 700 caravans on this park. About 500 of those are owned. And if you bought a caravan on a caravan park, you're not going to be paying a site fee every year and have continual disturbance from loud music into your caravan. So just please do bear that in mind as well. It's in our own self-interest not to disturb our own paying guests as well as the local residents who live to the rear. So that's the noise impact assessment. It was seen by your environmental protection team as part of the planning. If you read the amendments to the planning, the environmental protection team say, yes, we've seen the change in the position of the stage, we're happy with it. It is fine as long as you still observe the levels included in the noise impact assessment. And they recognise, the change in the plan recognise that that was as a result of us moving the stage round to poke into the park, with the speakers then going into the park, and also with excuse me, and also with the stage being positioned right adjacent to and backing onto the actual complex building. So that's the noise assessment. If councillors, you have any doubts about that, after what you hear from those objecting, or if you have any concerns about that, then we're more than happy for you to suggest, as part of any grant, if you're minded to grant this, that your environmental health officer should go out and check those levels. Indeed, if there were to be any complaints, we would make sure that would happen anyway, to make sure they are set correctly. I also sent to you then the noise management plan, councillors, which is how we, having met with the residents and read the objections, will mitigate the effect of any outdoor entertainment. And that's within your pack as well. It's 10 pages long. I would ask councillors that if you're minded to grant the application, that you do so with a condition that we implement and maintain this plan, and we will keep it up to date in light of any complaints, alterations or change in entertainment that we may do, and we're more than happy to provide the licensing authority with any updated copy as well. But the noise management plan, councillors, just sets out how we manage noise. Surprisingly enough, it's a noise management plan. It mentions that we can and have played music under the Live Music Act already. We can do that till 11 o'clock. It has a small stage area. On page 4, the plan talks about the restrictions already imposed as part of the planning application. Do you have? You'll have a copy of this as well, councillors. You will. This will be in your pack that you had. It mentions that we have a noise limiter installed, and that it's preset. It's set to the levels that are in the noise impact assessment. We must do that as part of the planning anyway, councillors. And that all amplified music is routed through that equipment. And then we keep a record of any complaints, should we receive any, and within that there is a telephone number for the security who are on park. And I think Rebecca's had that number provided to her by Tom. It's a mobile number for security. There's also an email address for people to complain to if they wish to do so. It mentions the small performance area, which is 2 metres by 2 metres. Please don't think this is anything like Glastonbury or anything similar. This is not going to be hosting any large bands. So it has a small stage area which points towards the park with the appropriate directional speakers. And that is a plan, councillors, which we are, as I say, happy is referenced on the premises licence, and we will implement and observe. So if I just turn to the objections, and obviously I'll get a chance to address these in my summing up, but if I just turn to just address those, it would be remiss if I didn't. Objectors are concerned about the quality of their life being impaired and peaceful life well-being being impaired, and that the outdoor music will become more of an issue. We have had outdoor music before. It's not being played through a limiter. We have had no complaint made to us of outdoor entertainment. We've had no complaint made to the environmental health officer regarding the outdoor entertainment, and we've had no complaint from Environmental Health to us. Indeed, your Environmental Protection team are happy as part of the planning process. I know this isn't the planning committee, but as part of the planning process, that we should set the limits indicated in the noise impact assessment. That's being done. There's a limiter there, which we haven't had before, and which we can plug, and which we will plug any amplified equipment into. Please also bear in mind, councillors, by law, we can do this anyway. This permission can be taken off us in the future should we cause disturbance or nuisance to local residents by way of the review mechanism. But we've had no complaints. Rebecca now, I think, has Tom's email address as well directly, so she could email Tom. Security are there from 5 at night, 5 p.m, right the way through to 9 o'clock the following morning, so they're there at all times from 5 p.m, and we also have a member of management outside those hours as well, working within the complexes, who's always there too. And we do have our own holiday makers to consider as well, councillors. There's reference that this would be every night of the week going to 2300. That is the request. That's what we could legally do under the Live Music Act. But we haven't, and we won't. Typically, during peak, so in other words, July, August, perhaps early September, we may have 3 or 4 performances a week of a 45-minute set. And this is likely to be 1 or 2 people in the stage area. But we may have at times, I guess you might have some cartoon characters who come on and do a bit of a set as well. So you might have Dora the Explorer or SpongeBob SquarePants or Noddy doing some sort of children's set. And that would also fall within these categories of entertainment we can do in any event. But to bear in mind, councillors, we have had films permission on this licence until 11 p.m, 365 days a year, and we haven't used that. So we are not going to be using that by any means every day, every week of the year. Indeed, the park is normally shut, I think, November through to February. It's obviously shut in the winter months, a bit cold. It'll depend on what the weather's like outside, councillors. You know, we can't give you a specific entertainment programme. If it's nice outside and the sun's out and we've got a nice crowd outside and the park's busy and buzzing, then we may well have more entertainment than we would otherwise. Outside peak, if it's outside peak, outside the months of July, August, early September, we may only have 2 or 3 occasions when we'll have live music outside. There's concerns that previous noise levels have been agreed in the January 2024 report have been exceeded. Councillors, we haven't actually used the limiter yet because we haven't played any music outdoors since it's been installed in February through the limiter, councillors. So they can't have been exceeded because we haven't yet used the limiter, and certainly we've had no complaints made to us about any noise from the stage area. I think we've had some unamplified music on the stage, but that isn't anything you can plug through the equipment. And then, councillors, there's mentions made that the level of noise from inside is not reasonable. Councillor, I would ask you to bear in mind, and I have referred your solicitor to a legal case, this is not about indoor music, this is about outdoors. This isn't a review of our licence. There are other mechanisms open for you today. Sorry, not today. Sorry, other mechanisms open for objectors, for residents, environmental health, should there be any existing noise nuisance, and there's a request to do something about that. Today you're looking at a variation to the outdoor hours, not the existing operation, and it shouldn't be treated as a review. Councillors, I'm going to be quiet now. You've listened to me for quite long enough. I'll invite questions, which I'm sure you may have, and thank you for listening.
Thank you. I'll go back to obviously the running order. Are there any of the objectors that have any points that they would like clarified from obviously the applicant here today? If you could introduce yourself and say who you are just for our recording, that would be helpful. Thank you.
Hello, yes, I'm Matthew Burrell. I've got a couple of observations, one of which is I actually live in Farmley Avenue, and I would argue that we are considerably closer than some of the residents in Jubilee Avenue. and we did not get any notices down our road. In fact, the only reason I found out about this was a chance Facebook post. And as I say, therefore, as I say, I've not had a lot of prepare for this. I've not seen the noise impact assessment, which I'd be very interested to see, because some of the figures seem unbelievable, to be honest. But I'd also be interested to know where the microphone is, the measurement microphone for the limiter is sighted, because it sure isn't in the little white box on the wall, because that wouldn't do any good whatsoever. I would also point out, although they say the applicant has said that the speakers are pointing into the park, and there is a building between this stage and the residents in, say, both Jubilee and Farmley Avenue, that also in the renovations was a big perspex and aluminium building which is directly opposite the stage, which would act as a huge reflector for said sound being pointed into the park. I'm not sure I've got anything else at the moment. But I say we have had, where there has been outdoor entertainment on the park previously for charity days, I believe, which are odd days in the peak season last year and in previous years. That noise has been excessive, but you know, I bought a house 25 years ago next to a holiday park, so you expect some, but what I don't expect is 7 days a week up till 11 o'clock to be allowed. I say, you know, I'm not saying it should be pin quiet. We bought a house next to a holiday park, as did the residents of Jubilee Avenue. However, there is reasonable sound.
Have you got any other points for clarification?
Not at the moment.
No. Mr. Smith, would you like to?
I think there were more. Okay, I think it was kind of a statement, but yes. So, not heard of the hearing. We are duty bound by law to display the notice of application along the boundary of the premises abutting the public highway. We actually went over and above by putting 9 on Jubilee Avenue, which does not abut. That's not a public highway abutting our premises. It's people's gardens that would abut it. We couldn't invite every resident in the 200 metres or so from the park. We invited those residents to the meeting who live on Jubilee Avenue, which is the road that runs directly behind the park councillors. Where is the limiter set? Well, the white box is where you plug your sound equipment into. So the limiter, there's not a microphone in that. You plug your equipment into that, and then your microphone's as part of the equipment. What is on the wall, the white box, is the actual AV equipment socket that takes you into the sound equipment, and you plug it into there, and then that's the limiter within the white box, councillors. The microphone, that would be part of the kit that you're using, but that is then plugged into the limiter. The metal structure which is opposite, I think that's been referred to as, that is the canopy, I think. I'm not too sure what he refers to, what Matthew refers to there, but that is the canopy. So it's a canopy that sits over the outdoor seating area as opposed to anything bouncing the music off. As we've said before, as I've explained, if you've got any concerns, we're more than happy for the environmental health officer to come and look at the noise levels when music's playing in the outdoor area. Thank you.
Our other objector, have you got any points of clarification or for questions? So I'll move to our committee members. Have you got any questions that you would like to ask our applicant today? Councillor Cousins.
Yes, please. If I may, to speak to the applicant, please. You seem to have covered everything extremely well. Obviously, you're a big business, and I can understand that, you know, you've dotted all the I's, crossed all the T's. That's exemplary. And a lot of the things that you've talked about today fall under the Live Music Act anyway. There is one thing, however, that I would like to ask you as to why it has been worded the way it's been worded, because I find it quite ambiguous, actually, which is the current condition states when live music and recorded music is played outdoors, the maximum noise level, 15 minutes from events, shall not exceed 65 decibels. This is on page 17, sorry. To be changed to when live and or recorded music is taking place outdoors, the maximum noise level will be set in line with the noise assessment previously approved, dated the 19th of Jan 24. This is the bit here which says, which may be amended from time to time in line with changes to the outdoor area. That to me is quite an ambiguous statement, and maybe would you consider removing? Yes.
Amendments to the outdoor area which would necessitate it, then we could make a variation to the licence. I'm looking at Mr. Kemp at this point, but
You
I
make
don't
a
have any particular problems with
through
that.
the proper
Yes,
system.
you could remove that, Councillor.
Yes, thank you. Thank you very much. That was all I had to ask. Thank you very much.
Yeah, thank you. That was one of the points that I'd actually marked up, because I did feel that wording was very loose, that time to time. So thank you for answering that. That's really helpful. Do we have any further questions from councillors? So have you got any further questions you would like to ask any of the objectors, or while you're here?
I assume I asked the objectors questions when they've made their points to you, Councillor. But yes, I'll leave it till then, Councillors. Thank you. I've finished until my summing up. Thank you.
We'll now move over to the objectors here. If you'd like to make your representations, if you've got anything you want to draw to the committee's attention. Obviously, we've got your number 1 and number 4 on the objectors, so we have read through those. So, but if you've got anything further you'd like to add to us,
Sorry, Councillor.
now's your opportunity.
Sorry, there was one final point. I had been led to believe that those attending today had been provided with the additional papers, including the noise impact assessment and the noise management report. I should just have added that, sorry.
Can someone confirm that? Thank you.
Yeah, but it did go out, I believe, but we can get a copy to them now.
It's not a case that we just purposefully ignored those people. We don't actually have their email addresses to send it, so it'd have to come through the councillors, and I'm led to believe you sent it
So
to
are
them.
you confirming that they have received it?
I understand it had it, yes.
So they have received it. Thank you. So we'll now move back to the objectors. Thank you.
Yeah, I'm saying I've received any information. Thank you. Appreciate that. Thank you. I think there's some confusion when I ask about how this is going to be monitored, and I believe as in terms of noise levels. I would say the equipment in the box is not where it is measured. So where is the measurement microphone? It's a pretty critical point.
If I could help, councillors, perhaps it explains in the noise impact assessment that the measurement is, and the readings I gave you, they are on page 16, Matthew, you don't mind me calling you Matthew, of the noise impact assessment, and that stipulates where those readings are, and the 76-73 is taken 10 metres from the front of the stage.
Yeah, and I understand that, but what you're talking about is noise restriction through this box, and that requires a live measurement microphone. You are talking about when they have made measurements in a environment on, say, you know, when it was being built or tested. To have live monitoring requires a measurement microphone positioned permanently attached to the piece of kit which is doing the either turning off of power or the reduction of sound levels. So where is that measurement microphone going to be
If
located?
you'd like to make your objection, it's not a to and fro conversation. So if
Well,
you'd like,
I'm trying
if you'd
to
like,
establish
if you can
where
make
that-
your objection, and then we can come
Fine.
back with questions.
I'm trying to establish where this live measurement microphone will control the sound levels when performances are live. When they are live policing the sound levels, that microphone placed, not what was done in the assessment, because we're talking about live measurement during performances, so that they can control. Does that make sense? Sorry. Is that, so, yeah. Sorry, it was that is why I'm.
Have you got anything you'd like to say? If you can introduce yourself, that's
Hi,
helpful.
my name's Rebecca Buson, so I'm a resident of Jubilee Avenue, and as referenced in the discussions here, I have been in contact with Tom with regards to concerns. With regards to the meeting that did take place on the 16th of March, it wasn't at Highfields Grange, which would have been more accessible for residents of Jubilee Avenue to access. It was actually taking place at Wheelie Park caravan site, which on a road where you have a demographic of elderly people and families with very young children, it's not always a possibility for people to be able to attend to make their objections clear. As we've discussed, I did email my concerns over to Tom, but prior to that, there has been a distinct lack of communication from Highfield Grange in terms of who we can actually contact when there are concerns. Having been a resident of Jubilee Avenue for almost 15 years now, I confirm there have been outdoor cinema events, there have been pool parties, there have been other outdoor events where potentially the noise has been, well, the noise has been excessive, it's no potential about it, but we may not have known what recourse to take, who we can actually contact to make our concerns known to the park, or some people on the road may not have access to the internet, may not know how to raise a noise complaint in terms of antisocial behaviour. Just to clarify that point, I have actually raised a noise complaint through the environmental health team since the reopening of the park for the I believe it was probably over the Easter season. I know we're only focusing now on the outdoor stage, but the level of noise from the indoor stage since some refurbishments have been made have been noticeably louder than previous years. In fact, I live in a house, it's not directly behind, but it's quite a close proximity to the clubhouse, and from my bedroom I can hear every word to every song that's being played. So I'm wondering whether any changes within that structure has affected the sound proofing at all. And I know it's not particularly relevant in terms of we're not discussing the indoor noise, but if the indoor noise is excessive as it is now, my concern is what is the outdoor noise going to be when or if a live stage is in place. Also going back to where it was mentioned about the live stage and maybe some acts being on the stage potentially with regards to children, is there any need for an outdoor stage till 11 o'clock at night? I'm not a party pooper. I go on holiday, I take my children away, but there has to be a compromise between what is appropriate for the park, what's good for the holiday makers, and what is good for the people that live in the local area. I do feel that there's been a distinct lack of communication up until recently with Highfields. We felt that we've been left out of any kind of decisions. We've not been notified when there have been events that are going on that may impact us. And I think that's probably where a lot of the discontent and the upset comes from. Sorry, that was long.
Do we have any questions of our objectors or anything we'd like clarifying at this point? Have you, as the representative, have you got any points you would like to address at this time? Thank you.
If it's okay, I'll just deal with clarification of what the objector has said in my summing up is probably the best place for me to do it. Thank you.
move on. So if there are no further questions from either the objectors or committee members, no further questions at this time. So we will move to the closing statements. So if you'd like to go first, and then we'll go to the objectors, and then we'll... No? Each party starting with the interested parties, stroke objectors, then the responsible authorities. Oh, finally the applicant. No, you are right. I will apologise for that. So if you've got any further closing comments you'd like to make, thank you.
Just say, I'd just like a clarification as to how the is going to work. Yes, so I would just like clarification as to how the live sound levels are going to be accurately policed on site, and whether the amplified equipment that will be used is the parks, or whether that would be indeed acts that come in, because that would also affect massively as to how much sound propagates from the premises.
Are you able to answer? No, that's fine. Have you got any? No, you're all done. Lovely. Move to, obviously, the applicant, if you could address those points and then do your summing up. Thank you.
Thanks, councillors. Yes, I'll just address Matthew's point. So I'm not a technician, but the noise limiter, it is a suppression system. So the way it acts is that the noise levels cannot go over those indicated in the noise impact assessment. When it approaches that, it suppresses, it keeps the levels down. And those levels, to answer your first question, are measured 10 metres in front of the stage. And so you can do that as a one-off, because you set the limiter, therefore you know it's not going to be over that level. You physically cannot get the music playing over that from the equipment. And everybody, any amplified act on that, in that small space, has to use the limiter. It has to go through the park's own AV equipment. And you can check it, the park can check it. They have these handheld devices, so you can even stand there and check 10 metres in front of the stage that it's not going over and above the levels indicated. But once you've set it, you shouldn't need to reset it. If we did get a complaint through security, the mobile number, then we would need to go out to Matthew's house, Rebecca's house, whoever it is, if they'd allow us, and just listen to the music. And then if it had to be turned down, it would have to be turned down, councillors. That's why we provided telephone numbers in the noise management plan. There is, within the noise impact assessment, there were noise readings taken at points 1 and 2, which were actually at Farmley Avenue. So there were actually noise readings taken and noise impact assessment made at those 2 points. And actually those 2 receptor points, being 1 and 2 on page 19, show the lowest of all the recordings in terms of music breakout, if that's some comfort to Matthew. That's on page 19 of your report. And on page 19 are the noise readings at NSR1 and NSR2. The projected readings at those two are -16 and -14 below background levels with the music played on the stage. And that's using the background levels that we did previously. And then you can see on page 18, NSR1 and NSR2, they are the noise monitoring points which are near to the road that the Matthew lives upon. So that's how the equipment works. Rebecca mentions that there'd been lack of communication from the park. We have a new general manager here. We did write to residents. We put lots of notices up. This is not a park, in my experience, that has ever experienced a lot of complaints or concerns from residents in terms of noise. We've not been told of any environmental health complaint yet, Rebecca, through environmental health. That will probably be coming through your team, I suspect, in due course. I think Rebecca's concern, however, is around the internal music, is what I'm understanding from from the show bar probably. Now, rather ironically, councillors, the show bar has just had a new roof put on it. So it's slightly concerning if we've taken the old roof off and put a new roof on, if Rebecca's now experiencing noise. But listen, you're not here, of course, councillors, to consider the internal music. I'm sure this will come from your environmental protection team, and we'll have to look into that complaint quite separately, councillors. But as I said, we're not asking for any later internal hours, councillors. We've already got those on the licence. Is there a need for a stage until 11 o'clock? Well, as I said, we can do it under the Live Music Act anyway, but no, we're very unlikely to be doing any entertainment until 11 o'clock at night. You never know. I can never say never, councillors. It's a holiday park, but that would be few and far between that we'll even be going beyond 7 o'clock at night, councillors. So that's just dealing with the points. To briefly sum up, your solicitor has a copy of the case of Manchester City Council and Taylor, and that just stresses that you're not here to review the existing licence. You're here to consider the variations sought, and any conditions imposed must relate to those variations sought. We're not here to consider the internal music levels or what time we're allowed to play music inside. I provided you with in your bundle a copy of the National Licensing Policy Framework, which is very much talking about, well, we need it to be an enabling piece of legislation, the Licensing Act. It's got to encourage businesses to innovate, to spend money, to invest in parks, whilst also protecting the amenities for local residents. So it's a balancing act between the two, councils. But that's always been the case, and the guidance was recently amended, which I'm sure your solicitor will be aware of, with paragraph 1.18, that when making decisions, councillors, then you should consider the need to promote growth and deliver economic benefits. And what I would stress here, councillors, there is no representation from the police, as you've asked Councillor Casey. There's no objection from environmental protection, which is particularly relevant, bearing in mind the variations sought. Not only that, but your environmental protection team has fed back positively on the planning permission and the change to the planning permission, indicating that they're happy as long as the levels within the noise impact assessment are maintained with the noise limiter. So, councillors, you have to make your decision under paragraph 9.43 and 9.44 on the evidence that you have, and attach any conditions that are appropriate and proportionate. And the decision for you is, in light of the fact there's no recorded complaints about any music outside, whether from residents, environmental health, police, ourselves, that we haven't used the limiter in the past, councillors, but we are duty bound now to do so under the noise management plan. We haven't had a noise management plan before, but we have one now that's going to be implemented for the outdoor area. That we're happy for the environmental health officer to come out and set it, and that we're happy to implement the noise management plan as a condition of any grant you make. So is it, councillors, on the evidence you've heard, appropriate and proportionate to reject the application entirely? Or is it appropriate, proportionate to grant, with the condition I'm suggesting, councillors, regarding the implementation and maintenance of the noise management plan? And of course, we're spending £5 million here. We don't want to be back with a review of our premises licence within a few weeks or months, councillors, because that's going to be an awful lot of money spent on a holiday park, which may then have its activities curtailed if we are breaching the licensing objectives, of which there's no record, no evidence, and no concerns from your responsible authorities. I'll finish now, councillors, and thank you very much for listening to me.
If everybody's happy, they've all had their say and asked all their questions, we will now retire to make our decision, and we'll get back with you as soon as we can. Thank you. welcome back everybody. Thank you for your patience. We've obviously made our decision today. So here goes. The subcommittee has given careful consideration to this application, the premises being Highfield Grange, Holiday Park, London Road, Clacton-on-Sea, Essex, CO169QY. A summary was provided by the TDC licensing manager Michael Cook, who stated that the premises is described as a caravan holiday park. The amendment as requested being on page 17 of the report, and the hours are 11 o'clock to 2300. All relevant authorities have been consulted and there have been no objections. Mr. Jonathan Smith attended as solicitor for the applicant. He introduced Mr. Andrew Kemp, who appeared online and is the licensing manager. Also present is the general manager, Tom Joyce. Mr. Smith, in his representation, stated that the park resort operates about 66 park resorts, with 4 being within TDC's local area. There has been about £5 million investment over the last 12 months on the site, including adventure play area refurbishment of a couple of venues on the site, amongst others. He stated there was a residents' meeting held on the 16th of March to explain the proposed application, with councillors also invited. With reference to residents not being made aware of the application, he stated there were a total of 19 notices put up, and Mr. Smith referred to the photos also provided. Mr. Smith referenced page 51 of the agenda with conditions 1 and 3 and states no representations have been received in regards to those conditions needing to be amended. A reference was made to the noise impact assessment and that the noise will be managed in line with the noise plan. And it was said that an AV equipment has been installed, with the stage being reorientated to point into the park away from Jubilee Avenue. He also stated that the environmental officers were content with the impact was mitigated. It was also stated that there are about 700 caravans on the site, with about 500 privately owned, and as such it would not be in their best interest to disturb their residents. He further states that all records of complaints are kept and all music is run through the noise limiter. Outdoor music has been played in the past without the noise limiter and there had been no complaint received. There is always security and a manager on site. Typically July, August and September. There may be performances 2 or 3 times a week. There may also be children's performances, but there is no intention to use it 365 days. Objector, Mr. Matthew B, stated that he arguably was one of the nearest residents to the park. He had not seen consultation and only came across it via a Facebook post. In peak season in previous years, noise has been excessive. He admits buying a house next to a holiday park and expects some noise, but not 365 days. Objector, Miss Rebecca B, attended, but with no further question for the applicant. Mr. Matthew had a question as to how the noise will be measured. He was referred to page 16 of the noise impact assessment by Mr. Smith, who further explained. Miss Rebecca stated she is a resident of Jubilee Avenue for about 15 years. In the past there has been noise, but they were unaware of who and how to complain, and she had in fact made a complaint to the environmental health team. She stated there had been a distinct lack of communication with no notification or information for when there are events, which is the main discontent. Mr. Matthew, in closing, asked how the sound would be policed, whether it will be the park's equipment or the performer's own equipment. And Miss Rebecca had no further comments in closing. In closing, Mr. Smith addressed Mr. Matthew, questioning in stating that the noise limiter is set to suppress any sound when it goes beyond the requisite level. As to lack of communications, it was said that there is now a new manager and in any event they are unaware of any such complaints in the past. He stated there is unlikely to be entertainment until 11 PM and if any it will be few and far between. The Council has considered statutory guidance and the Licensing Authority's policy. In reaching its decision, we have taken into account the views expressed by the applicant, the objectors, and note the other 5 objections received in relation to this application. The subcommittee has also considered the licensing objectives, namely the prevention of crime and disorder, public safety, the prevention of public nuisance and the protection of children from harm. The application has been determined on its own merit, and the decision is to grant the variation of hours for outdoor activity as requested, with this being from 11 AM to 2300 PM Mondays to Sundays. Appendix 2, Condition 1, shown in the agenda bundle on page 17, is removed. Annex 3, Condition 3, is amended to read as follows. When live and or recorded music is taking place outdoors, the maximum noise level will be set in line with the noise assessment previously agreed and dated the 19th of January 2024. For the purpose of all parties involved, we wish to remind you that should there be any noise or concerns, you can and should report to the environmental team. There has been no advice from the legal advisors in arriving at our decision, and anyone aggrieved by this decision can appeal to the Magistrates' Court within the relevant statutory period. You will get notification of the decision within 5 days. Thank you all. So we'll just go back to the agenda and the date of the next scheduled meeting. Oh, no, we're not into the meeting. We've got another one this afternoon. Sorry, it's carrying on. It's a long morning. Thank you all, and we'll adjourn the meeting again.